drinking.
Well,
The concern was that he was drinking. And
but Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
Okay, pause. This is already getting messy. The defense just dropped an ALR dismissal order like it's a plot twist in a courtroom drama. Translation: the supposed suspension on the defendant's license may have never existed. That means the entire basis for the judge's earlier order could be built on sand. Question is, does that collapse the whole case? Or does the court order as a court order rule still win out?
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you
And-
run his license, please, state?
Your Honor, this should be eligible to.
Did it just become eligible, or when was it eligible? You know what, let's do this. I have a line of people, I've got arraignments. Let me put this off a little bit because this is gonna take a
I
lot
had
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge.
what,
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
what day was it lifted?
4/2/2025, from what I can see on the license. It's the license.
And what are the days that he's alleged to be driving?
The second judge, let me double check.
And does he have an interlock as well?
Yes, Judge, yes, interlock, he was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension
It was
and
not
it
an
was
ALR
lifted.
suspension.
Whoa, did you catch that? The judge just went full fire and brimstone. And here's the key legal nugget. Even if pretrial services gave the wrong info, the judge's order overrides everything. Think of it like a parent telling you bedtime at 9, even if your babysitter says midnight. One voice rules the house, the courts.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
The
you.
order suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024, end
Pereira,
date 6/3/2025, and the lift date comes in at.
And then if that,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the second and third. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pre-trial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment.
Thank you, Judge.
Counsel,
Judge, just to be clear, is he permitted to drive now?
as long as he has the interlock, he's got a valid license and he has insurance, yes.
Does the affidavit need to be?
Yeah, we'll rescind it. Don't. The worst possible thing you could do now is drink. If you drink, you're gonna freaking lose it. Do you understand? Or put anything in your body that has alcohol in it. Don't.
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay?
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time.
Microphone hash notice how drinking is the ultimate landmine here. The judge isn't just worried about licenses and suspensions. Alcohol is the trigger that escalates everything. In legal terms, violating bond conditions with alcohol can turn a defendant's world upside down. In human terms, one bad decision and you're back in jail before you can even say cheers.
Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of
To
unfair to
see
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can we stand down for a bit?
I'm sorry?
Can we
Just-
stand down to see if she's available to
She
Zoom?
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
So,
Oh, hello. Can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault.
Come on.
And then he picks up an indecent.
No. We plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Microphone hash here comes the shocker. What started as a felony sexual assault charge is now being pled down to a misdemeanor indecent assault. For the audience, this isn't just legal wordplay. The difference between a felony and misdemeanor can be the difference between years in prison and probation. It's like trading a thunderstorm for a drizzle, at least on paper.
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you.
Shh.
Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income, I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, asked that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them.
Microphone hash, this is the gut punch moment. The victim just dismantled the plea deal in real time, calling it out as unjust. And here's where legal theory meets raw human reality. The law may allow a plea bargain, But if a survivor feels silenced, was justice really served? What do you think? Should victim impact reshape deals? Or should courts stick to procedure?
Stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently, no one's consulted her regarding this thing,
Mhm.
see whether they,
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the plea
barely
and the
spoke
reasons
to you
for
a
it.
couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely. And I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, Your Honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's
I
something that
think
you
it's
want
unfair
to
to
do.
my client because normally we do the plea, then we have the state.
Microphone hash, that's actually a really important moment. Legally, victims have the right to be heard under most state laws, but not necessarily the power to dictate outcomes. The judge here is walking a tightrope, respecting her voice without letting it derail the plea entirely. A balancing act between compassion and courtroom efficiency.
And just because she spoke first, now she's going to bust the deal?
She's not busting anything. I mean,
I'm
I
the
was,
victim. I am the victim. How do you even
Please.
speak about? Sorry.
please,
Yes,
it's
sir.
okay.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk or we can set it for trial. It's your decision, Mr.
We do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
Okay. It's going to do 10 days, Justin. Huh? 10 days. Otherwise, he loses his job.
It's better than the current deal from our perspective.
Okay.
Thank you, Judge.
Good.
Okay. Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah. Let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this, and if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
The U.S. citizen, Judge.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was 2 years of okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results, all things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and SANE results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the records, the court records, after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflects my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Yes, thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer. You know,